Yes, good afternoon, everybody. My name is David Pryor. I'm an employment lawyer. I work in the workplace relations team at Jobs Australia. Welcome to our webinar this afternoon about general protections. I'd first like to make an acknowledgement of country. In the spirit of reconciliation, Jobs Australia acknowledges the Wurundjeri people as traditional custodians of the land. We pay our respects to their elders, past and present. So I will now commence our webinar on general protections. I will go through a number of slides. If there are any particular questions that anybody has as we're going through, my colleague Britt may take those, and if there's something that needs to be addressed during the webinar, we can do that. Otherwise, I would ask that we leave questions till the end, and we'll have about a 10-minute session where there'll be an opportunity for you to ask questions for me to respond to. And I will also be asking Britt to move through the slides when I say the words, as I'm about to now. Next slide, please. So general protections under the Fair Work Act. These are protections which have been put into the Act in relation to workplace rights. And these are rights exercised by employees in the workplace, broadly described as employment entitlements, and the freedom to exercise and enforce those entitlements. These are things such as the ability to engage in industrial activity, which encompasses the freedom to be or not to be a member of an industrial association, so freedom of association, and to participate in lawful activities, including those of an industrial association. So as a delegate or as a member of a union in terms of industrial activities in a workplace. Other protections include protection from discrimination and also sham arrangements. By that, we mean sham contracting arrangements where a person purports to be employed in a contracting arrangement and in the circumstances, there are indicia of employment. And when that matter is brought to a head, if the person files a general protections claim, then the Commission will investigate and ask the employer to demonstrate reasons why it is not, in fact, an employment relationship. Next slide, please. So the main sections in the Fair Work Act start at section 336, which deals with protecting workplace rights, as we've just briefly touched on, protecting freedom of association, providing protection from workplace discrimination, and also providing effective relief for employees who have been discriminated against, victimised, or have experienced other unfair treatment. So in that regard, if somebody believes that they've been victimised or experienced unfair treatment, they may have explored that through dispute settlement or a resolution procedure. They may have in fact resigned, and they may be considering a constructive dismissal claim, or they may simply decide that the way that they wish to take the matter further is to bring a general protections claim in relation to an allegation of victimisation or being treated differently to somebody else in the workplace. Now, it's an interesting and very complex regime, general protections. This is an opportunity to have an overview of the relevant sections. In a further session in the future, we may dive deeper into general protections and give some examples and perhaps go more through process. We will touch on that very generally in this session today. Next slide, please. So section 340, adverse action is taken because of a prescribed reason. So it sets out a prescription, the general protections provisions which aim to protect employees from adverse action taken because of a particular prescribed reason. So this is a reason that the applicant is claiming because of this reason, there's been a breach of the general protections provisions. So 340 goes into a number of breakdowns. A person must not take adverse action against another person because the other person has a workplace right or has or has not exercised a workplace right. I may raise an issue with my employer through my supervisor about something I've seen in the workplace, about something that I've observed that I don't believe is compliant with OH&S or seems to be a risk. or proposes not to, or has any time proposed or proposed not to exercise a workplace right or to prevent the exercise. So it's going through all the possibilities of, I've raised an issue, or I've raised an issue and management have said, look, please hold off on that. Don't do anything till we investigate. And or I've raised an issue or I've exercised the intention to raise the issue. So it's a very broad protection in terms of the indicia that it includes. It's not simply that something has occurred and I'm reacting to it. It may be that I intend to, or I proposed or propose not to exercise a right in the workplace. This is an example of exactly how complicated and how complex these provisions can be, and they can also move very quickly. The most important thing for employers in terms of avoiding being the subject of general protections or an adverse action claim is to keep very clear notes in relation to meetings that you have with your employees, particularly if you're having a meeting and you have a witness, the witness for management being somebody to take notes, so that if at a later date you're put to the burden of justifying why you've taken a particular action, or that you in fact have not taken a different action, or what the prescribed reason is for the action that you have taken, that you have evidence that's contemporaneous with the meeting, so that you have something to draw on to explain to a third party, in the view of the employer, what was actually occurred, or in fact, what was actually discussed. Next slide, please. So other general protections which use, I'm just moving my screen, which use the provisions because 346 is in regards to industrial activities. 351 is in relation to discrimination, that I believe I've been discriminated against either because of an attribute that I have, or I've been discriminated against because of an attribute. And there are a range of attributes: race, sex, sexual orientation, and a number of other things which cover discrimination. And one of the more historical areas in that context is pregnancy and in relation to maternity leave. 352, regarding temporary absence in relation to illness or injury. I've had time off. You've discriminated against me on the basis of the fact that I have actually taken time off. And now, just to give an example of how fast and how quick this can move, Workforce in the last week has covered a particular adverse action claim where a person had a one-day absence. So they've been out of the workplace for one day. They returned to work the next day to a meeting, and they were terminated without notice at that meeting on the basis of absenteeism. They then presented a medical certificate, and then they brought an adverse action claim on the basis that they were discriminated against, and raised a general protection in regard to the temporary absence in relation to their illness. The Commission on that particular matter ordered that the general protections claim was not successful on the basis that the employee had not raised the issue with management at the time being the day when that occurred. So that is how fast these types of matters can actually move. So in the interest of going through the general protections matters that we're discussing, that is a very good example of how fast general protections can move. A one-day absence, action the next day, and that of itself is what brought about the claim by the employee. And in that particular instance, the employer was not aware of the certificate on the day in question and received the certificate after the event. And on that basis, it was deemed that there was no general protections claim on foot. Lastly, section 354, regarding coverage by particular instruments, including provisions of the National Employment Standards. So I've questioned something about the period of notice, or I've questioned something about one of the employment standards that are applicable in the workplace. And I believe that the employer has adversely treated me because I've either raised a question or in terms of the application of the provisions. So I brought a general protections claim on that basis. Next slide, please. Why was the adverse action taken? It comes down to a question of fact, which must be answered with consideration of all the facts established in the proceeding. Unless the adverse action was actually taken because of a prescribed reason, there will be no breach of the general protection provisions. So the example I just gave about the person in the workplace who took a one-day absence, returned to work the next day, presented a medical certificate, and was terminated. They were terminated by the employer on the basis of their activity the previous day. The employer was not aware of the medical certificate when they made that decision. So in that case, the adverse action was not taken because of a prescribed reason. So the adverse action was not taken because of the medical certificate, which was provided to the employer for the purposes of the coverage of the period of leave taken the previous day for personal illness. It was because they were unaware of it at the time. The workplace right need only be a reason and not the only reason for the action. So I've raised an issue with management. I'm going through performance review. I've got unsatisfactory performance. I've seen an arcing electrical circuit in the hallway. I've raised the issue with that. And I bring a general protections claim to say, well, I raised the issue about the unsafe PowerPoint and I'm being performance managed. So it can be a reason, and I would be claiming that the adverse action was on the basis that I raised the issue in relation to the arcing unsafe PowerPoint. So if the action was taken solely for another reason, such as serious misconduct at work, then there would be no breach. So for example, I'm being investigated for something that's happened in the workplace. If it's that issue and I raised the issue about the arcing unsafe electrical plug, the serious misconduct was another reason. The reason that I've raised in relation to the adverse action was not the only thing that was happening. And this is why we say at Jobs Australia that if you think you're likely to be in a meeting with an employee, and if you think there may be an issue taken with something that you're going to discuss, we're always happy to discuss that with the employer first before the meetings occurred. Likewise, if you receive a general protections claim from an employee, the time frame for the employer to respond is extremely short. It is 7 days from when you actually receive the application filed by the applicant. So if I got it at lunchtime today, Wednesday, I've got till close of business Wednesday of next week. And what we really appreciate is if employers receive general protections applications, please be very quick to provide them to us so that we can give you advice about how to respond in terms of the employer response and to enable you to get that in so that you can deal with the process. We'll go into the process a little bit later in today's discussion, just an overarching coverage of what the steps are and basically what happens in a linear fashion. Next slide, please. So sorry, I bumped the mute. I think I mentioned very briefly before action in relation to a pregnant employee. For instance, if it's taken against a pregnant employee, there'll be no breach of the general protections provisions unless the pregnancy was the reason for taking the adverse action. So the fact that somebody is at work and they're pregnant and they're about to apply for maternity leave is not of itself a reason for adverse action. It is only relevant if it is something to do with the reason why they are claiming an adverse action. So for example, everybody has been asked to move boxes. The boxes weigh 8 kilos. It would not be appropriate, for example, to ask somebody who's pregnant in the workplace to pick up or move a box of 8 kilos, for example. Pregnancy of itself does not establish immunity from adverse action. So it's not the fact that the person is pregnant and they're in the workplace, it's the fact that it would be inappropriate to ask somebody to lift a box over a certain weight. And it would be inappropriate to ask somebody who's currently pregnant in the workplace to lift a box of 8 kilos And I'm just using that as an example. So what we also say at Jobs Australia for employers is, if you think you're likely to have a problem with something, happy to have a chat about what you're about to speak to your employee about in relation to matters pertaining to either an investigation, in relation to performance, or in relation to allegations that have a disciplinary impact. And if you think there's a potential for adverse action, it's always best to have a discussion about that before you have the meeting, if that's at all possible. Next slide, please. So 360, section 360 is multiple reasons. A person may take action for a particular reason if the reasons for the action include that reason. So this is why it's most important for employers to keep accurate notes of meetings and discussions with an employee in relation to discipline and in relation to performance, or even if somebody's raised a workplace health and safety issue for the employer to take away, on the basis that under section 360, well, there can be multiple reasons. If the reasons for the action include the reason that has been raised for the general protections. And again, this is a matter of being very carefully dissected post an application being received. And it's not unusual for applicants to tick a number of boxes. They don't necessarily tick one. And then you as the employer are put to the burden with the reverse onus of proof of demonstrating why you have not, in fact, relied on that reason, or in fact have not taken a particular course of action for a prohibited or for a reason or for a workplace right under one of the sections that we've just discussed. Next slide, please. So section 344 deals with undue influence or pressure. Section 345, misrepresentations. And lastly, section 348, coercion. Undue influence. Look, I want you to take annual leave in a month's time. Please don't take it next week when you've got your planned booked overseas holiday. We need you to finish the report. Misrepresentation, well, of course, I'll let you take the leave at a later date. Coercion, it's debatable whether, in terms of undue influence, if I've asked somebody to make a change and I have attempted to apply or exert force or pressure on the basis that there's an employment relationship between an employer and employee, and it's questionable whether that's an equal relationship in terms of power and influence. Sometimes, as I think I've just said, employees, if somebody is filing a general protections or an adverse action claim, they may simply, unfortunately, tick every box, in which case you may need to work through the set of facts, and there may be some repetition in terms of explaining from the employer's perspective what has occurred in terms of what the employee believes has transpired in linear fashion over the course of whatever the number of events or the event is that is the alleged subject matter or the adverse action or general protections claim. Next slide, please. So there is a rebuttable presumption, which simply means a reverse onus. So under 361, the reason for the action to be presumed unless proved otherwise. So from the employer's perspective, the applicant has raised a general protections claim, they've ticked a number of boxes, and in relation to the employer's response, it is to demonstrate why it did not happen, or it did not happen for the reason that the applicant has alleged. And this becomes a lot more straightforward and easier to unpack if at the time, weeks, days, months earlier, contemporaneous notes were kept, particularly if there were meetings, and there may well be meetings one-on-one, and there may then be notes taken in relation to what was discussed. There may be emails, there may have been workplace discussions or correspondence. So if in an application in relation to a contravention, it's alleged to a person took or is taking part in a particular reason with a particular intent or an outcome, and taking that action for that reason or without that intention would constitute a contravention. So this could be a live issue where it says or is taking action for a particular reason. So it could be something that's actually ongoing. you've got a performance management issue, the person's raised discrimination, or they've raised some other adverse action in relation to an attribute or the way they're being treated, or whether they've exercised a workplace right, or whether they're alleging that you've tried to coerce them or misrepresent something. And here you can see how very quickly it can become extremely complicated and complex in terms of unpacking to determine from a factual matrix what's occurred in what order, what evidence do we have, what discussions occurred, who was present, and the onus being on the employer to demonstrate that in fact it didn't happen, or in fact it didn't happen for the reason prescribed, or in fact there were a number of reasons and we're not relying on the reason that the applicant is prescribing. Next slide, please. So section 345, misrepresentation. A person must not knowingly or recklessly make a false or misleading representation about the workplace rights of another person or the exercise or effect of the exercise of a workplace right. So I know that Barry's unhappy about what we're proposing. The ladder, the lift, the gantry out the back, the thing that we're talking about. Yeah, look, you know, we're getting it fixed next week, or, you know, they're coming in next month. I've got an invoice. If you're having discussions with people about making a representation about something in the workplace, a question, an issue, something that has been raised, you just need to remember that the most important thing is it needs to be factual, within your knowledge and based on some form of evidence. If at a later date you're required to explain. If you're not sure about something, you can always say to an employee, look, I'll take that on notice, or I'll get back to you, or can you bring that to the Workplace Health and Safety Committee, or can you send me an email and I'll respond to it. Subsection 1 does not apply if the person to whom the representation is made would not be expected to rely upon it. So if somebody has told a colleague something, they're not the manager, there's no expectation for them to act on the thing that another employee has put to them. That would be a defence to subsection 1 on the basis that the representation that might have been made to another employee, for example, it's not reasonable to consider that employee would be expected to rely upon it, to take action, to respond to it. And again, this all comes down to a matter of unpacking once a general protections or adverse action claim has been received, to see in the factual matrix what's occurred in what order, who has spoken to whom, what has happened, what's alleged to have occurred, and then unpack that with evidence to see what, from the employer's perspective, the factual matrix reveals in terms of what's been relied upon, who's spoken to whom, and in what context, and whether the person that's been spoken to has the responsibility for responding. Next slide, please. So what is the protection? A person must not deliberately make a false or misleading representation about the workplace rights of another person or the effects or the exercise of a workplace right by another person. So the protection is that you are protected if you're making correct, accurate representations about the workplace right of another person. So again, if you're a manager or a supervisor, if you're in any doubt, speak to your direct line manager about the meeting or the discussion that you're about to have. And if you're going to a meeting, if you're being asked to respond, stop and consider whether, you know, there's an expectation that it's your responsibility to respond, and whether you've spoken to the person involved, or whether you need to go and speak to the person that another person has suggested, has put something forward, or is raising an issue in the workplace, and they're not raising it on behalf of another person. Next slide, please. Are there exceptions? Again, this does not apply if the person to whom the representation is made would not be expected to rely upon it. This is one of the most important unpacking areas of general protections, on the basis of, well, hang on, they spoke to me, I'm the manager, or they spoke to Barry, Barry sat on it, Barry didn't tell anyone, this is the first we're hearing about it, Barry may or may not be the manager, and there may or may not be an expectation for Barry or Mary, whoever the person is that they've spoken to take action on the basis of what they've been told, and whether there's an expectation that, having been told something, they had an obligation to pass it on. Next slide, please. So the fair work process, and I just wanted to go through this very briefly. The fair work process involves a number of steps. So the applicant has filed the general protections or adverse action claim. The employer receives it. They've got a week to respond. They go to a conciliation conference. At that conference, it's either resolved or not resolved. And I need to point out that general protections is uncapped damages. So in an unfair dismissal claim, for example, it boils down to the maximum, which is 26 weeks. This is uncapped. There has been one claim already that went successfully to the federal court, and the payout was in the vicinity of 1.3 million. That is not a general outcome, but given the breadth and the complexity of this area, and the fact that it's uncapped damages, means that it is an extremely serious part of the workplace relations regime, and a very important and fundamental section or suite of clauses within the Fair Work Act. If the matter cannot be resolved by an apology, compensation, whatever is being sought by the applicant, there's an election by the applicant whether they wish to proceed. So the applicant's got two choices: drop the matter or take it further if it can't be resolved. A second conference, which is not always guaranteed, with an actual panel member rather than a conciliator. And if that's not resolved, then the applicant, again, has the choice of either ceasing the matter or proceeding to full arbitration. That's arbitration in the Fair Work Commission. And if the employer doesn't consent to that, it goes to the federal court. The federal court is a cost jurisdiction, which means not only is there a burden in preparing witness statements, submissions, and being prepared to put your witnesses into evidence and be cross-examined, but if you're unsuccessful, there may be a cost order against you, being the employer, for example. So again, I can't stress enough, this is a very serious, very complex area of workplace relations. Jobs Australia is set up to advise and assist members with how to avoid being in a general protections or adverse action position. However, if you are, you may certainly be in contact with the workplace relations team, and we can provide you with consultancy services on a fee-for-service basis to assist members to prepare for conciliation and attend conciliation and attempt to resolve issues in the first instance before they may then ultimately escalate to the potential for a full arbitration. So prevention is better than cure. It is always best to be proactive with things in the workplace. It is always best to make sure where you can to keep good notes, have witnesses to conversations and meetings with employees. That is not always possible. In the instance of the woman who raised the issue, having taken a one-day absence in the workplace, on day 2, when she was terminated, the matter crystallized in 48 hours. It wasn't even over the course of a week, it was that quick. And these things can escalate extremely quickly. Next slide, please. So in conclusion, it is prudent to keep notes of meetings conducted with employees and also when conducting one-on-one discussions with an employee. So you don't need to keep notes with a one-on-one discussion with an employee. You may make some notes while you're talking, or you may ultimately make some diary notes at the conclusion of the meeting on the basis that we had a meeting on Wednesday at 1 o'clock, discuss blah, blah, blah. It's always good, having done that at a later date, if you need to refer to it, to refer to contemporaneous notes. And that simply means notes taken at the time, not a day, a week, or a month later when you're trying to remember what you did last Wednesday week at 4:30. And when you reflect on that, it's actually a lot harder, even if you're looking at a diary or an electronic calendar, to work out exactly what happened over that half an hour by using your best recollection. It's also recommended to have a note taker as a management support person present during performance or disciplinary meetings with an employee. Well, for 2 reasons. One, to keep an accurate record of what's said, so you can maintain eye contact with your employee. And also at a later date, if these types of issues are raised, or discrimination, or there's a dispute about what was discussed during the course of the meeting. Lastly, and if any doubt, it's always good practice to obtain advice about how to proceed with a matter involving an employee or a complex issue before meeting and discussing with your employee. Always try and do that before before you've met. We can always talk to you after the event, but it's always more profitable to have a discussion about what you intend to do tomorrow rather than the meeting that occurred yesterday. But we're able to assist to provide guidance in any event. Can I have the next slide, please? So on behalf of Jobs Australia, I would just like to thank you all for attending this webinar today. And I'm now open to any questions in the remaining time that we have for the discussion.
Thanks, David. We've got no questions there at the moment. So if you'd like to pop any questions that you have into the chat box, or alternatively, you can raise your hand and we can unmute you and you can ask the question directly to David. So we'll just wait here for a few more minutes, and if any questions come through, David will be here to answer them. Thank you. Okay, David, a question's just come through.
Yes.
In terms of note takers for performance-related meetings, are there any parameters or recommendations on who might be best placed to be present if you have no specific HR manager? For example, is it appropriate to have someone external, or is it appropriate to arrange by agreement?
Okay, if you're a small organisation or a close-knit team, the most important thing is who's not at the meeting. So if it's a close-knit team and there is no HR nominated person, it's best to look at who's appropriate to be there, preferably not somebody that's in the team that may be part of the subject matter of whatever's being discussed. So it's always best to have somebody that's outside the loop from the issue or the question that's being raised in terms of misconduct or a disciplinary matter in relation to things that have occurred in the workplace. And that obviously includes whoever the complainant or the people affected by whatever's alleged to have occurred or not occurred. So in the first instance, it's always best that it's not somebody in that immediate group. And if there's no tiers of management, if arbitrarily the only manager in the workplace is the person running the meeting, it can be somebody from the board or from the committee. That's not always recommended in terms of them being ultimately the next tier of management from the point of view of whether a matter escalates. But it can otherwise be somebody external that has no correlation to the workplace. And that would just need to be raised at the start of the meeting to say, Bob or Mary is here for the purposes of taking notes, and that person obviously has confidentiality explained to them, so that they're obviously not at liberty to talk about what's discussed at the meeting at a later date. And when I say not discuss outside the context of taking notes to provide obviously to the employer.
Okay, thanks, David. Okay, so there's no more questions coming through, so we might wrap up today's session. If you do have any further questions, as David has mentioned, feel free to get in touch with the team. So you can contact them on 1-800-331-915, or alternatively, you can email ja@ja.com.au. The details are on the screen now. We will be sending the recording and the slides out this afternoon, so they will be available for you to look over. But as mentioned, any more questions, get in touch with the team. So thanks, David. Thanks everyone for attending today, and enjoy the rest of your afternoon.
Thank you all.